Deep in the Florida Everglades, a hastily built detention site has earned the nickname Alligator Alcatraz, and it now sits at the center of a high-stakes courtroom fight. The outcome could reshape how far states can go when federal environmental law is in the way. The compound stands on the Dade Collier Training and Transition Airport, a lonely airstrip inside the federally protected Big Cypress National Preserve. With rows of tents, chain-link cells, and room for thousands, the facility supports the Trump administration's push to detain and deport undocumented immigrants. A coalition of environmental groups and the Miccosukee tribe has sued, saying construction and operation violate the National Environmental Policy Act, or NEPA. Passed 55 years ago, NEPA forces federal agencies to study environmental impacts and invite public comment before greenlighting major projects. The plaintiffs say none of that happened here. Their worries are specific and local. Polluted runoff from new pavement, floodlighting visible for miles, and extra traffic through habitat used by endangered species such as the Florida panther and the Florida bonneted bat. For the Miccosukee, the stakes are also cultural. Tribal leaders argue the site sits on ancestral land and that they were never consulted, a legal requirement when federal action affects indigenous territory. Florida counters that no federal action exists to trigger NEPA because the project is funded and built by the state. The Justice Department backs that view. Governor Ron DeSantis' office has framed a recent court setback as the work of an activist judge, insisting deportations will continue regardless. That setback arrived on August 7, 2025, when United States District Judge Kathleen Williams issued a 14-day temporary restraining order. It freezes new construction, no paving, no fencing, no additional infrastructure, while the case moves forward. Current detainees remain in place and immigration operations continue. The pause might be brief, but the implications are long-term. Billions of taxpayer dollars have gone into restoring the fragile Everglades. Critics warned that letting a state sidestep NEPA for a federal purpose could open doors to other projects that chip away at the ecosystem. Separately, civil rights attorneys have filed another lawsuit claiming detainees are being denied lawyers and other constitutional protections, adding pressure to shut the facility down. For now, bulldozers are idle on the runway, and environmental experts are combing the legal filings for what could become a landmark precedent. If the court upholds the restraining order, it would reaffirm that projects with federal objectives, even when state-funded, must clear the same environmental hurdles as any other. If the state prevails, it could weaken one of the nation's bedrock conservation laws and leave the Everglades and other protected lands more vulnerable to politically driven development. The next hearing will determine whether the halt becomes a longer injunction or construction roars back to life. Either way, the fight over Alligator Alcatraz is no longer just about one detention site. It has become a test of where environmental stewardship, tribal sovereignty, and immigration policy collide, right in the heart of America's river of grass.